Not all confidentiality agreements or non-disclosure agreements, NDAs, are alike. Sometimes very large corporations have a concern that it's difficult to manage all of their personnel across a very large enterprise, companies like IBM or Hewlett-Packard. And as a result, they like to include a provision in their standard forms of NDAs that are uncomfortable sometimes for disclosures of confidential or sensitive information. Those clauses are referred to as residuals clauses, and they go something like this. Nothing in this agreement will limit the use of information that is retained in the unaided memories of the recipient's personnel. The concept is that the large company may be receiving information from the discloser of information, and it's such a large enterprise that maybe several years later on an unrelated project, the personnel may be involved in something similar or related to the information. They may reuse that information and not even know where they once learned it. And it's not with a purpose of deceit, and it's not with an intent to steal or in any way wrong the original discloser of the information, but they reuse that information, and the large company doesn't want to be sued under the NDA as a result. Well, that's a scary thing for parties that are disclosing very sensitive information, but let's think about what's really being jeopardized. We're really talking about trade secret protection here. We're saying that the raw information might be reused by the recipient party, but I'm often often successful in negotiating some additional language around those residual clauses, even with IBM or HP, something to the effect of nothing in this contract limits the use of information retained in unaided memories, but neither is a license granted under any patent or under any copyright or other intellectual property right. And so even if the personnel might use the basic ideas, that doesn't entitle them to practice a patented invention, let's say, and so they would be stopped if there is additional coverage via patent for what has been disclosed. Nor would it allow them to make copies of information that had been disclosed. That would be a copyright matter. Just the basic ideas that they've learned, and that might be important, but it's just the ideas and not other intellectual property licenses. We might also be successful at including language like nothing restricts it so long as it's not memorized or done with an intent to deceive or to evade the restrictions. If it's then in the unaided memories, then the term would apply. Well, obviously this is a concern to parties that are often smaller, dealing with these large organizations who are providing information, and the large organization appears to be asking permission to freely avoid the restrictions of the confidentiality agreement. And it's already scary dealing with the large company because if there ever were a problem, the small company may feel at a disadvantage if it had to enforce the agreement in court. So these residual clauses are scary things indeed. But I would encourage you to think about several things. One is you can always negotiate those additional terms, and I've had a lot of success at getting that in there. They're used to these kinds of questions, and we can ordinarily get the language to a happy medium and a comfortable place for both parties. But more important than that, think about the nature of the information that's being provided. If the discloser is providing financial forecasts for the next quarter or two, personnel of the other company retaining that information in their memories and somehow finding an opportunity to use that several years down the road is unlikely to be a problem. If, on the other hand, you are revealing an elegant but simple solution to a very complicated problem, well, indeed, they might be able to remember that and might be able to put that to good use at a later time. If you're doing that, of course, it might be advisable to think of patent protection, not relying on trade secrets alone, which would allow you to prevent the other company from practicing that same invention. So really the nature of the information to be disclosed makes the residuals clause scary or not scary, and you should be thinking about the nature of it and whether you can get the language to a more comfortable place in your negotiation. Residuals clauses are important. They are here to stay. You should expect to see them, and I encourage you to be on the lookout for them when you're reviewing non-disclosure agreements. Consult an attorney if you have further questions.